Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. You're listening to episode number 673. I'm Stuart Clark.
And I'm Aaron.
I think we've got an interesting topic to talk about today, at least one that I always, may be interesting in the context of us, boring estates lawyers. But I think it's an interesting kind of idea to wrap your head around. And it's a relatively recent case called Schutz Estate, which is a 2023 decision in Ontario, 2023 ONSC 3959. And why I like this case today is it shows, or I think it has an excellent kind of summary of a tool that can be used within the context of passing of accounts, and that is the ability to insulate claims that may otherwise be statute-barred by limitation periods, and you can insulate them if you bring that same claim within the context of a passing of accounts. And that's because, I'll get this in a second, because there's case law out there, Wall and Shaw being the most prominent example, which stands with the proposition, in effect, that there are no limitation periods for objections raised as part of a notice of objection. So Schutz Estate kind of picks up on that a bit, and we'll get to it eventually, but it kind of picks up on it a bit and shows the ability to use that lack of limitation period in the passing of accounts to insulate claims that may otherwise be statute barred. So maybe Aaron, it's a great time maybe for you to kind of just give us a quick summary, I suppose, on Wall and Shaw and limitation periods of passing accounts more generally.
Sure. So Wall and Shaw arrived on the heels of a case called Armitage and Salvation Army. And so in Armitage, they specifically left open the question of whether a notice of objection might be subject to a limitation period. And so in Wall and Shaw, the Ontario Court of Appeal, sitting as the divisional court, considered a dispute that had arisen between the appellant estate trustee and one of the beneficiaries of the estate. And the respondent beneficiary proceeded to issue a notice of application to pass accounts. And it pertained to compensation that the estate trustee had taken, and notice of objection were eventually filed by the respondent and the other beneficiaries. And so here the appellant sought to strike out the beneficiary's notice of objection on several grounds, and all of those grounds were rejected by the motions judge. And then on appeal, the appellant only advanced one ground, which was specifically that the motions judge erred in refusing to apply the 2-year limitation period in Section 4 of the Limitations Act to bar the respondent's notice of objection pertaining to those estate accounts for periods in excess of 2 years. And so he tried to argue by analogy that the notice of objection is essentially a counterclaim and therefore commences a proceeding for the purposes of the Ontario Rules of Civil Procedure. The Court of Appeal rejected this argument and the appeal was dismissed.
Yeah, so exactly right. So Wall and Shaw, it's a few years old now, but it's Court of Appeal, Divisional Court, which is really the Court of Appeal, sitting saying, look, a notice of objection advanced within the context of a passing accounts does not meet the threshold of a claim within the Limitations Act. Therefore, there is no limitation period that applies to the notice of objection. So you person passing your accounts can't say, wait a second, you can't advance that objection because that objection is statute barred because more than 2 years has passed, or whatever the limitation period you're saying applies to it has passed. So it's kind of universally been kind of summarized as there are no limitation periods in passings of accounts. And so you say, well, that's great. Well, why does that matter? Who cares? Passive accounts is this weird kind of quirky thing that exists within the estates and trust law world, but it's not really something that we care about too much. It's just, an audit of the administration of the estate or trust, whatever. But not so fast. And the reason why we say not so fast is because the Estates Act, more specifically Section 49 sub 3 of the Estates Act in Ontario, says that within the context of a passing of accounts, if the judge finds there has been a breach of trust or loss or negligence or something like that by the person passing their accounts, they can order damages against that person within the passing of accounts without the objector having to start a new statement of claim or action against the person to recover that. So that's important, right? So you're a beneficiary of an estate. You think the executor sold, the property that you say should have been worth $1 million. They sold it under value for $500,000, and you think there's been a $500,000 loss to the estate. If you advance that objection in your passing of accounts, and the court agrees, well, 49.3 of the Estates Act says that they can order that $500,000 as a damages against the executor within the passing accounts itself without you having to straight up sue them separately for negligence. That's important, right? Because now if you add those two things together, you have a situation where Wallinshaw says there is no limitation period for objections. So even if this objection relates to something that happened 4 years ago and you're saying there's a 2-year limitation period, well, Wallinshaw says that objection itself can be advanced notwithstanding the fact that, the limitation period may otherwise be expired on a straight up claim. And if you prove that objection, 49.3 says I can order damages against you within the actual passing of itself. So those two things together are important, but why, limitation periods or the lack thereof within passing accounts can really be important if you're an executor and a beneficiary of that too. So that then pivots us to the Schutz Estate decision. The 2023 decision of Ontario, 2023 ONSC 3959. And it kind of picks up on an interesting concept, which is then, okay, extending that Wallinshaw Section 49.3 Estates Act thing forward, can you insulate claims that may otherwise be statute-barred if you straight up sued on them? Can you insulate those claims if you bring the claim within the context of a passing of accounts? And in Schutz Estate, I won't get into too much detail here. Most of it doesn't concern the Wallinshaw limitation period issue. But within the fight, it was a contested passing of accounts. And within the context of that passing accounts, one of the beneficiaries, a couple of beneficiaries argued basically a PECOR situation, right? When a PECOR, presumption of resulting trust, basically said a property that was between the deceased and the executor personally was held in resulting trust and should have been brought back to the estate. The executor said, well, too bad, so sad, too much time has passed for you to advance that argument. So even if you would have won on that argument, the limitation period for you to claim a PECOR argument has passed, and therefore, you can't object for that anymore. Court kind of goes over all the case law and comes to Wallinshaw and says, well, look, Wallinshaw says there is no limitation period on objection. Well, this isn't a straight up lawsuit where they're suing you or be seeking directions on the return of that property. This is an objection saying, hey, wait a second, executor, I think the starting balance of these accounts is wrong because it doesn't have that property as part of the accounts, and I'm objecting to the omission of that property, and there is no limitation period under Wallinshaw to that. So therefore, please, explain that objection. And if the court ultimately says, geez, you're right, there is no, there's no justification that should have been held in resulting trust and passed back, well, 49.3 lets me order damages against you. So it's this interesting concept that the court kind of confirms that, yeah, even if this lawsuit in isolation on its own may be statute barred, if you slip it over and bring it as part of a passing of accounts, there's a scenario where you can insulate that limitation period, insulate that claim, and keep it live just by virtue of the fact that it's brought within a passing account, which I think is very interesting.
Yeah, you'll have to remind me, Stuart, because I don't quite remember all the facts in that case. But was there do you know if there was a release or a formal release that was signed by the beneficiaries in the Schutz case?
Oh, geez. You put me on the spot. The answer to that is I have absolutely no idea.
Okay.
But my guess is no, right? Because by the very fact that there is a passing of accounts to a live accounts, you'd imagine a release had not been signed. Now, I don't know that for sure. But just, kind of using putting two together, I would imagine not. Because typically it's one or the other, right? If you're an executive administering a estate, you either ask the beneficiaries to sign a release saying, yep, everything's good here, failing which you pass your accounts where the court provides that same blessing and release on behalf of the beneficiaries. Here, obviously, the beneficiaries are objecting live to that issue within the context of passing accounts, which implies to me that a release has not been signed, but I can't say that for sure. But it's kind of, it shows, and the starting balance is a great way. I think to take a step back for a second. In Schutz, it was the use of the failure of the starting balance That was the objection. The starting balance for this estate is wrong. It should have included this property. That's a great way to insulate a lot of claims. You can see how that can apply to a lot of things. Hey, you say that you were gifted $500,000 by mom 4 years ago that I don't think you can justify. Well, I think the starting balance of the estate is wrong. I think it should be $500,000 more. Oh, you say mom gave you insert, heirloom here before she died and it's not showing in the balance. Well, even if I may be statute barred from straight up suing you for the recovery of that, or mom's estate may be statute barred from suing you to recover that, I can potentially insulate that claim, depending on the circumstances, within the context of a passing accounts by saying, well, the starting of the balance of the estate is wrong. You've sworn to the fact that the starting balance of the estate is $1 million. Well, I think it's actually $1 million plus the value of what I think is missing. And that's how you can kind of get that claim in. And if you're proven right, under 49.3 of the Estates Act, the court has the ability to award damages against the executor to return whatever it was, to the estate. It's an interesting concept, though. But yeah, no. So I think Schutz Estate and Wall and Shaw kind of working together provides a new tool, I guess, to be tool to keep in your back pocket if you're both the beneficiary as well as an estates lawyer, kind of thinking about claims that you can advance on behalf of your client. Which is okay. Well, if you're a beneficiary and you want to advance a claim against the executor that may itself be statute barred for limitation periods, is there a way that you can kind of bring that claim under the purview of a passing of accounts? And in doing so, can you potentially save it from that limitation period? And it's certainly something to keep in mind, because Schutz Estate certainly seems to suggest yes. And, Wall and Shaw obviously says there's no no limitation periods on a passing accounts generally. So it seems like it's a fairly, it's a proven way, in effect, to bring claims before the court that may otherwise be barred.
And I just want to contrast that position with, being someone who's a junior lawyer. I think maybe there's a key takeaway as a sort of practical advice here for people in my position, or you might be acting as an estate trustee. I think perhaps err on the side of caution by preparing a formal release from the beneficiaries. You pass accounts just to make sure that, everything is on the up and up. And, you'll save a lot of headache in the future if, your accounts are challenged by any one of the beneficiaries.
Yeah, no, exactly, right? Because, if this executor in the Schutz Estate had a release from the beneficiaries confirming the starting balance, for even a short period of time, the beneficiaries of the estate from date of death to 6 months later, well, then that property claim probably couldn't be in that next passing, because you're saying, well, you've already confirmed the starting balance. You said the starting balance was X and you signed a release for that. But it's that open question of allowing that starting balance to float a bit, where the court hasn't confirmed it, that allows these claims to kind of be brought in and potentially insulated and shielded from limitation periods by the passing accounts process. But yeah, no, it's a very good point, Aaron, and it's definitely something to keep your mind live to on both sides of the coin. If you are both on for the executor, you want to make sure you try to limit that exposure by passing accounts, getting releases. If you're on for the beneficiary, you can think, are there some creative ways that I can bring claims forward that themselves may otherwise be barred by limitation periods if I bring them forward within the context of the passing accounts? But yeah, no, it's a really interesting case against Schutz Estate, and kind of picking up the baton from Wall and Shaw and continuing that thought process of there being no limitation periods if they exist within the context of a notice of objection. But yeah, I think that brings us to the end of our podcast today. If anyone out there has any questions, please feel free to email us at info@hollandhall.com, or you can send a message, I'm sure, through other means to me or Aaron directly. But until next time, I'm Stuart Clark.
And I'm Aaron.
Thank you very much.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.